thanks for the invitation. I think this is a very important event because as far as I know, this is the first time in Germany, and I think also in continental Europe, that the themes of race, colonialism, and Eurocentrism are connected to migration law. So congratulations on the initiative, and I'm very happy to contribute. I want to discuss with you the case law of the two European courts since 2014, because since then our, I think, shared perception is that this case law since Glijvia has taken a statist turn, a conservative turn. There's a rupture with the previous case law. I will try to convince you that this is not the case, but that's what we all consider to be a rupture in case law is simply a manifestation of an underlying deep structure of the case law of the European Court and of European law more in general. This is part of my talk is part of a larger book project in which I study international migration law as a colonial phenomenon, starting in the earliest century and continuing until today. I use the term coloniality. And I think I have to explain it. It has been developed, it has been coined by, I think, Aníbal Quijano and other decolonial scholars. And they use it to refer to put into words that, yes, there has been political decolonization. So former colonies have become independent. But as we all know, economically and in a military sense, they're still highly dependent on powerful states in Europe and North America. Coloniality is used, and I will use it to refer to the colonial and ideological matrix, to the set of ideas that have been developed during colonialism to legitimize colonialism, and that are still part of our mental makeup and part of the political structure of law in Europe. So the concepts used to justify colonialism are still at work in European law. And in that manner, they continue to justify domination by, among others, Europe of the global south. Anthony Anghie, in his phenomenal book on international law, uses a different term, but I think he refers to the same phenomenon. He refers to the ongoing colonial structure of international law. So that's how I use the word coloniality. So this means that history is important, that history matters. And that history is not just a matter of something that's in the past that we can ignore because we live today, and only if you're interested, you look at it. But I think that the work of decolonial scholars and of Anthony Anghie, for example, show that history is at work and that it matters where you begin your analysis. If we begin our analysis of the court's case law in 2015, which is the usual thing, like in 2015 we had this crisis and then everything changed, then you will not see the impact of colonialism in case law. For that you have to go back, I think, to at least the post-World War II era, and in my case I will go back to the beginning of colonialism, because then you see a very long and continuing history. Now I had a beautiful James Baldwin quote for you. James Baldwin, in this quote that I hit upon a couple of weeks ago, he says, "In great pain and terror, one begins to assess the history which has placed one where one is." So he says history places us where we are now, and which has formed one's point of view. And then he explains, to my great relief, the words "in great pain and terror," which are a bit grandiloquent, right? In great pain and terror, because thereafter, one enters into battle with that historical creation, namely oneself, and attempts to recreate oneself according to a principle more humane and more liberating. One begins to attempt to achieve a level of personal maturity and freedom which robs freedom of its tyrannical power and also changes history. He wrote this in 1965. And I think that may help to explain the enormous language he uses. And he says we need history and we need to revisit history in order to change ourselves and to change history. One of the ways in which we can see history today is this map. This is a map it's a visualization of the global passport index, and the countries that are white on the map, those citizens, people like us, need visa for less than 100 countries in the world, and the countries that are black on the map, those people need visa for more than 100 countries in the world. Now, this visualizes the inequality in global mobility. And I think, and I will leave it at that and then go on to the next slide, go on to the core of my talk. I think it is very hard not to see colonialism here. It's very hard not to see it. Okay, my book will about this. It will be a 200 version of this one sentence. So I will now continue because I want to do a very technical analysis, a legal analysis of recent European case law. And for that, before I get to this case law, I first need to introduce you to provisions of European law, which you probably are not, which most people are not aware of. European law, the European Convention of Human Rights is from 1950, and the EEC treaty was ratified in was signed in 1957. In these days, Europe was still a colonial continent, and colonialism was alive and kicking. European states were busy reformulating it, changing it into a Commonwealth structure, but it was very much there. And the war in Algeria in 1957 was at its peak. Article 56 of the European Convention of Human Rights provides that when becoming a party to the convention, states can indicate whether or not the convention will apply to territories for whose international relations they are responsible. That is the cleansed term for colonies. Yeah, so they can say, well, it applies or it does not apply, because the drafters of the convention, in particular the United Kingdom and France, wanted to be able to do things in their colonies that they could not do at home, because it was taken for granted that in colonies, well, you may have to beat a bit harder, and you may need to resort to more violence. When this was discussed, the later president of Senegal, the first president of Senegal, Léopold Senghor, who was a member of the French Parliament for strange reasons as part of this federalization of the French Empire, he said he was furious at this. He was furious, and so he exclaimed at one point, I thought we were drafting the convention, the European Convention for Human Rights, but we're drafting the Convention for European Human Rights, and the pun is sharper in French. I thought we were drafting the La Convention Européenne des Droits de l'Homme, but it turns out we are drafting La Convention des Droits de l'Homme Européen. So we're drafting the Convention for the Rights of European Human Beings. The third paragraph of the same article, which is still in the convention, says that if you extend application of the convention to your colonies, then the application will, then the provisions will be applied with due regard to local requirements. So you should be aware that the rights that you're protecting the rights of colonized people, which reflects the same logic. And that's what all the handbooks say about this provision, if they mention it at all, because we rather ignore it these days. That you can do a bit more in your colonies than at home, even if you apply the convention. EU law has a comparable provision, which I will skip. It's Article 355 now. And Nadine El-Enani referred to this in her keynote. Pio Hensen and Stefan Jonsson have indicated that this is an echo of the idea of Eurafrique, of Eurafrica, the idea that Europe and Africa would be one unit where which would be good for all in the old-fashioned colonial sense. A second notion that is in the convention is the notion of emergency in Article 15 of the European Convention of Human Rights, and we will see that it's also in the TFEU. Now, you might say emergency is not a colonial notion. However, it is. As John Reynolds has shown in his book Empire, Emergency and International Law, and he builds on an earlier book by Nasir Hussain called The Jurisprudence of Emergency, they show that emergency as a legal notion was developed in the colonies. It was developed for colonial rule, because colonial rule required in the colonies a split legality. It required applying one set of norms to colonizers, but another set of norms to the colonized peoples. And you see this in all colonies. You see it in criminal law. So you cannot apply the same criminal law to natives and to European colonizers. Family law, private law. You see, there had to be two legalities, and they also introduced this emergency came out of criminal law and public order law, where you used against colonized people things that you did not want to use against the colonizers. So you made a split legal system. And John Reynolds shows that the notion of emergency as a tool of governance was then imported after the Second World War from the colonies as a legal notion. So emergency is a notion that is explicitly cleansed of its colonial origins, but that has its roots in colonialism. The point I was trying to make is that in European law, you can, although it has been drafted at a moment that pure colonialism was out of fashion, that you can see the notion of split legality in, let's say, as a kind of archaeological findings in the treaties. What I will now try to show you is that you can also see this in the case law of the two European courts. There are three forms, three legal techniques with which you can split legality. One is to say, for a particular group of situations, the law does not apply. That is the colonial clause, paragraph 1. When you become a party to the European Convention on Human Rights, you can declare that the convention does not apply in Algeria or Suriname or Ghana. The second form is, well, we are enlightened Western powers, and we do apply the convention, but with due regard for local requirements. That's the second version, to create a split legality. And the third is to apply the notion of emergency to a particular kind of cases. And I think that that is what the two European courts do. I will take you through this. The first judgment, Paul, can you give me a warning 5 minutes before my time runs out? Because I can get so excited about the details of these cases that I may take, that I think I need you. So the first case is the EU-Turkey case, where 3 litigants on the Greek islands brought before the General Court the text concluded between the EU and Turkey in order to end a migration across the Aegean. And that then resulted in the terrible situations in the camps on the Greek islands. This was a direct result of the EU-Turkey statement. The court decided, the court discovered in regardless of the text of the statement itself, that the statement had not been concluded by the EU, but by the 28 member states who happened to be together in the same room. Now, this is, for those of you who are still in law school, don't do this at a law school exam, it's wrong. And the court knows it. This is a direct violation of the URTA doctrine, which is case law and which was codified in the TFEU. It's a fundamental principle of EU law that member states cannot decide by themselves whether their acts are covered by EU law or not, because EU law itself, let's say, tells us whether EU law applies. Yeah, EU law is not at the free disposition of the member states, but EU law itself decides whether it applies. And EU law applies when an EU competence is being addressed in whole or in part in an act of the EU of these guys in the room, yeah, because we don't know whether we have to say EU or member states. In this case, the EU-Turkey statement says something about visa policy, about something that is covered by EU law and that has been completely harmonized by EU law. And therefore, the EU-Turkey statement, at least if you're making a law school exam, is an act of the EU, and it cannot be anything else. Yeah. For political reasons, the thing was the issue was too touchy-feely, too difficult, and the court obviously wanted to sidestep the whole thing for good reasons, because it would have risked giving a very explosive judgment. And it also wanted to make sure that it could not be approached on the same topic via preliminary questions of Greek courts. And therefore, it could not say, the correct answer at the law school exam would have been, this is not an act against which individuals can litigate, because it doesn't address you directly. But the court wanted to ditch the whole case altogether and also insulate itself against preliminary questions. And therefore it said, in a very messy way, that it was the 28 member states. They say in an incorrect manner, and they know it. I think you can read in the text, if you really read carefully, that they're deeply uneasy about what they're doing. It's not the usual crystal clear reasoning. So they say law doesn't apply. That's the first example of what I reinterpret as applying a legal technique that Europe inherited from its own colonial era. The second example is the humanitarian visa judgment. And both cases are here. Well, the Court of Justice was applied on a completely different thing. Was approached by a Belgian court with a case about Syrian nationals who applied for a visa for Belgium so as to be able to apply for asylum in Belgium. And the question was, has this been harmonized by EU law? Yes or no? Is this an EU law? Is this a case within the competence of the court? Here in my analysis, the court had two opposing but equally perfect technical approaches at its disposal. The court used one. They said, these people have applied for a short-term visa. We have the visa code about that has been harmonized, so that's within EU competence. And it's a short-term visa that has been rejected by the Belgian authorities, but actually this is not a short-term visa, because EU law itself decides, and not applicants, not member states, EU law itself decides what the character of an act is. Because these people want to stay in Belgium for more than 3 months, and something is only a short-term visa if you want to stay less than three months. So we qualify this as a long-term visa, and therefore we are not competent to rule on the case. Yeah, the Advocate General had used the other, I think, equally perfect legal argument. He had said they applied for a short-term visa, and a short-term visa was rejected. It's true that if you say that they will stay for more than 3 months, then I want to point out that in the visa code, the fact that people may want to stay for more than 3 months is a ground for rejecting an application for a visa. Like, you don't get a visa because there's a risk that you will stay. But there's also an option to exempt people from this, to make an exception and to say, well, you may be willing to stay for more than 3 months, but nonetheless, we grant you a visa on humanitarian grounds. So the Advocate General says there is a situation in which people who want to stay for longer than 3 months and apply for a short-term visa can get a short-term visa. And I think, he said, I think this is exactly what's at stake here. He has a kind of fallback argument. He says, even if they want to stay for longer than 3 months, their stay will be there. They will go to Belgium on the basis of their short-term visa. And then they will apply for asylum. And at that moment, their residence, their presence in Belgium will not be based on the short-term visa, but on their asylum application as a consequence of the Procedures Directive. So they will use the short-term visa only for a short term. And then he continued to say, and this visa has to be granted because the alternative of not granting them the visa is forcing them to stay in Aleppo. And this was at the time when Aleppo was being shot to pieces by the Syrian army. So here, the Court of Justice used, unlike in the EU-Turkey case, which was simply entirely incorrect, here they used a perfect argument to say law doesn't apply, EU law doesn't apply. They had an alternative. The European Court of Human Rights was faced with the same issue, with Syrians from Aleppo applying for a visa for Belgium in order to ask for asylum, until last year, when the European Court gave this decision. The court had for decades held that the exercise of the acts or omissions of diplomatic or consular officials is an act of jurisdiction. If there's an interaction between a member state's consular or diplomatic agent and an individual, that state exercises jurisdiction over that individual. In this case, the court added something. They said it's only an act of jurisdiction if the consular agent interacts with its own subjects. So Germany only exercises jurisdiction at the German consulate in regard to Germans and not in regard to others. The court held that it's not possible to trigger unilaterally jurisdiction by addressing a request to a state with whom applicants had no prior connection. You cannot, these Syrians could not create a jurisdictional link with Belgium by applying for a visa. Of course, what the court leaves out of its argumentation is that Belgium has created a jurisdictional link with Syrians by introducing a visa obligation for Syrians and for having it enforced through by airlines. So it ignores the map I just showed a few minutes ago. But the European Court used a different legal technique to say, I don't apply. I don't have competence. The convention doesn't apply to this kind of cases. I have now 5 minutes. Okay, then I will. I have equally detailed analysis of the other things. Okay, so indeed, I will skip the other two examples. Trust me, it's equally exciting and let's say, legal technical fun to do this. And the court in all these cases constructs ways to end up with a split legality, to allow for due regard to local circumstances, or to rely on the notion of emergency. Now, I promised you, I think I implicitly promised you with the James Baldwin quote, a perspective of something more humane and more liberating, because the analysis I have of the case law of the European courts makes me very, very, very skeptical about trying to improve this case law, or trying to make the sharp points a bit less sharp. I don't claim that there is a kind of colonial determinism at work. The court sometimes gives different judgments, like Hisijama, which I think is a departure from that colonial structure. Well, there is always an ambiguity. There's no determinism, but I think there is a fundamental logic. Now, what does it help? What does it? Can it help us to make analysis like this? First of all, I think not making this kind of analysis gives free rein to this logic and makes it possible for these courts and for academics to continue to replicate it and therefore to implicitly justify it. So I don't see how we can do anything else than to point out that this is, and to make this kind of analysis. I have three suggestions for where we might go. The first is Strasbourg is one of the three regional human rights courts which can give judgment like this. The other two human rights courts have fundamentally different case law on migration. The texts of the provisions they apply are similar or even identical to the one that Strasbourg interprets. Strasbourg tends to completely ignore this case law, except when it suits it. But it never refers to the fact that on asylum, on cross-border accountability, like in the humanitarian visa cases, the Inter-American Court of Human Rights has fundamentally different case law. And I think it's important to, the Human Rights Committee, which has a completely different function, also at some points has fundamentally different case law than Strasbourg on jurisdiction, for example. I think it's important to study these sources, even though, especially in the case of the African Commission and Court of Human Rights, it's very hard to do so because they don't have a good search machine. You have to go through PDF files one by one to discover whether they're even about migration. It's a lot, it takes a lot of time. But I think it's important to study this, to analyze it, and to confront the Strasbourg court with the fact that they give a very peculiar interpretation of international law, even though they claim in standard case law, like it's a well-established rule of international law. Well, not according to the other two regional human rights courts. That's one. Second, this kind of analysis allows for very innovative approaches like the one proposed by Tendai Yatsume in her article, Migration as Decolonization. And I'll merely mention her. So I think this kind of analysis, the approach she proposes there, and it's tentative, I think it's not perfect, but it's a completely new way of looking at international migration law. She essentially says, yes, communities have the right to decide about admission, but these communities are transnational. It's the communities that are that have the power to do this are transnational communities. Thirdly, and that's my last point, I think we might take perspectives of outsiders more seriously. And at the risk of making myself deeply unpopular, I will say something about the position of Belarus. It is in the texts that I read, it's taken for granted that Belarus is a rogue state and that Belarus does things no proper state does to migrants. I'm not being paid by the Secret Service of Belarus, although maybe they would be interested in doing so, but I think it's a complete deformation of international law. One of the core principles that the European Court of Human Rights has been applying over in this conservative turn is to give more emphasis to the well-established international law right of states to control migration. Belarus is exercising that well-established right of states to control migration, but they do it in a way that Europe doesn't like. But they are a sovereign state. If they want to give visa to Syrians, they're completely free to do that. Then is there something wrong with Belarus not preventing or encouraging the departure of people from their territory towards Poland? Nora Marquardt has written a beautiful article about the right to leave any country, including your own. And she has pointed out that, to translate it to Belarus, Belarus does not have the right to limit the right to leave Belarus based on public order interests of Poland. It can limit that right based on its own public order interests. So I think there's no ground for Belarus, but Belarus cannot, legally speaking, limit the right of people to leave Belarus for Poland. Is Belarus, so Belarus is not violating international law vis-a-vis European countries. Is it violating international law vis-a-vis Syrians, Yemenites, Eritreans, Iraqis? Not by granting them a visa. I think these people know exactly what they do. They can see internet just like we do, and they can see what their colleagues, what their fellow countrymen in this border zone are going through, which is terrible, and which is partly instigated by the Belarusian authorities. But so Belarus is not violating the rights by granting their visa. It may be violating, or I guess it's violating their right by beating them up. Yeah, so that's certainly true. So I think, legally speaking, the violation of international law of Belarus is very limited. And is identical to the violation of international law to Poland. Poland violates international law in much more major ways by disregarding non-refoulement law. So I just want to say, to conclude, that if you become aware of the Eurocentrism that is a fundamental feature, not an incidental accident, a fundamental feature of the field of law that we study, it becomes possible to see the sometimes even reasonableness of actors that we consider as rogue actors, like Belarus, like Turkey, like Libya, like Morocco, when they let loose, because that's the terminology that's being used, when they let loose a set of former colonial subjects to a territory where they were supposed not to be. Thank you. I look forward to your response.
Thank you so much. I think I can say on behalf of all your listeners that I'm very sorry to have to cut you short then. But I think you really did great advertisement for your past and future works for everyone here to follow. I think you were the perfect speaker for this time slot. It's a Sunday morning, which is usually pretty hard for speakers, but I think you managed perfectly. And right now we are open to questions from the board. I would like just to start with one specific question to you, because I wouldn't like anyone to leave this conference without having an idea in mind of what post-colonialism actually is. So if you don't mind, would you at once just elaborate on what post-colonialism means to you? Is it just the pretty banal statement that colonialism has passed and that we're now living in the world past colonialism or post-colonialism, or is colonialism today still a reality in some ways? How would you define the concept?
I'm the wrong person to ask, because I'm learning on these points. So but I will share with you what I learned. And there different people use the term in different ways. But so why I get excited, as I hope I got across to you about using the term, is that colonialism has been with us between 1500 and 1960. That's 4.5 centuries. And there has been an extensive system to legitimize this, and international law was part of that. In the analysis of Tony Engie in his really phenomenal book from 2005, please, I try to read it every year. It's very rich, it's very well written, it's beautiful. So if you take anything, read Tony Engie's book. International law didn't exist before colonization. International law came about in the effort to legitimize colonization, and it's still with us. And in the half century since political decolonization, that structure is still with us. Newly independent states in the 1960s and 70s thought, we are now international actors as well. We want to change international law and undo its colonial character, and they failed. That's essentially the analysis that Engie makes in that book. They failed. And so the colonial structure is still there, even though formal colonial relations have mostly ended. Although I'm Dutch, and so we still have a few quite painful things there. That's I think the importance of the term is in being aware that that colonialism as a conceptual concept, as a concept that's part and parcel of international law, and that we have to deal with it, to face it.
Thank you very much for your thoughts. And well, Mr. Goodman.
Yeah, I do not agree with your view to the EU-Turkey treaty. As far as I have understood international law, for binding decisions, you need that the partners follow the interior rules. Interior rule in the EU is that the parliament has to accept an international treaty. Without parliament, you can't do it. The same in Turkish law. At that time, it was Article 90 of their constitution, but not without parliament, they couldn't bind the state. So ECJ was right to say there was nothing. There was the EU treaty with the deal, not treaty, the deal with Turkey is an example of democracy deficit, not of a wrong decision of a court.
Do we take a few more questions? So, like we did in previous sessions, or are there no further questions?
So there is a question from the online audience from Katarina Zybritsky, and she says, many thanks for your intriguing presentation. Intuitively, I find your reading convincing. However, I'm not sure I fully understood your argument, at least with regard to the CJEU's judgments. In particular, how do you react to the common reading that these judgments reflect the court's deference to the EU legislator? Would you reject that reading or integrate it into your argument? And if so, how? Okay, so just a short question from Tobias Seitz. What was the title of the book, please?
So let's take one more.
Okay, I do have let's say, more practical question, but I think it's really exciting and very interesting. I also remember I have been in a conference in South Africa once to the decolonization of the curriculum, of the law school curriculum over there. And I found it very interesting. At those times, the discussion was very much based on the language they used to study. And I was just wondering how we actually can think of decolonization of our curriculum. Maybe you have thoughts about practical thoughts about how we actually can introduce a bit more decolonization, a less Eurocentric approach in legal education. That would be very interesting to me.
Right, shall I? Because we have three questions. I think there's two questions. Doing the exciting, detailed thing, like going at my technical analysis of the court's and the Court of Justice's case law. In the visa case, I think the court was not wrong in doing what it did, and it's just an accident that I think it was in the EU-Turkey case, because there was no other way to ditch the case. In the visa case, they had a free choice. There were two perfectly convincing options, and of course, the court opted for the one that allowed it not to address the substance of the case. Because otherwise it might have ended up like the Advocate General ruling that Belgium had to grant a visa, and that would have been very explosive. I don't know about Germany, but in the Netherlands, on the morning, so before the judgment, the Volkskrant, the, let's say, okay, progressive, well-thinking newspaper, opened with "Court may bomb Dublin, may blast Dublin." So that was the excitement that was there, the apprehension that was there. On the Turkey case, the court does not use your argumentation. The court does a reading of the text and of the minutes and of the location of the meeting where the statement was adopted. If it would follow your reasoning, it would abdicate towards the council, because then the council could say, well, we don't want parliament, so we will give this the form of a press release. So that was too much for them even. So the core of my argument is not that the court did something that was wrong at the exam, although I'm convinced it did. It did not use your argument, and for very fundamental reasons. But it's it used the law doesn't apply. We cannot have the structure that I see is that we cannot apply European law, be it the European Convention on Human Rights or EU law, to these foreign subjects that are at our borders, that are on our islands or at our borders, this kind of liminal law. We cannot have these liminal subjects. We cannot afford to apply our Cadillac style, our Rolls-Royce version of law, because it wasn't made for it. It wasn't made to be applied to hoi polloi. It wasn't made to be applied to masses, to the huddled masses. And so we have to choose. Either we lower the standards, but then we suffer, because then we don't have this we don't have this Rolls-Royce law anymore. Or we have to split. We have to split this legality, and that's what they do. So they make sure that I will take the liberty to do in 2 minutes something that I had to skip. The due regard to local circumstances. Yeah, that's the second version to split the legality. You do apply your own law, but you have due regard for local circumstances. There is standard case law on detention conditions of the Strasbourg court, which says we require 3 square meters of space for a detainee. On Lampedusa in 2014, people had 1.2 square meters. That's less than half. And they had stinking toilets with no closed doors. There were 2 showers for 30 people. It was insufferable. And the court said, well, because of due regard to local circumstances, this was not a violation of Article 3. So they ditched their own case law because, so that pattern, I think, is hard to disregard. European courts think we cannot afford to apply normal law to these subjects at our borders. The curriculum, that's a real struggle for me, because I think it's about, for lawyers, it's about if you adapt your terminology. I mean, law is terminology. So if we cannot cleanse our terminology, because it's what we do. So I think for lawyers, the problem is even more exciting about how can you address this structure. In my own teaching, I try to do 2 things, and that takes me a lot of time. And it's basically like, I think we have now learned to be aware, or to that let's say an alarm bell should go off when we only give readings by men. I think, well, for each class, I want to have at least 1 reading from the Global South about this subject. And sometimes it takes me days to find something, and maybe it's not even something good, but it should be there. And also to have case law or treaties from the Global South. So to simply dig into this website of the African Commission of Human Rights, and to open all these PDFs. Now that's where I am. I think that's a very first beginning, but at least it unsettles a bit the idea that it makes it possible for students to identify that if the Strasbourg court says that something is a well-established rule of international law, well, maybe we have to check that. Maybe we have to check whether other parts of the world agree with that.
I think the only thing we still have left is the book title of Tony Aggie's book.
Oh, I always forget it, but I guess. Is it the chat?
Oh, right.
Imperialism, Sovereignty, and the Making of International Law. A must read. Beautiful book, elegantly written, and only 200 pages or something.
I think we still have time for a question if addressed. Otherwise, well, we will even talk about the Belarusian situation in a while. And I would really love you to repeat your comment back then with all the panelists. But there's still something from Laura, yeah?
There is one more question in the chat from Claudia Baumann. Thank you very much for your inspiring input. As a historian, I'm curious as to how you decide on the time frame, beginning of 20th century, and the sources you take into account in your analysis. Yes. Okay, so I repeat the question, which comes from Claudia Baumann. Thank you very much for your inspiring input. As a historian, I'm curious as to how you decide on the time frame, beginning of 20th century, and the sources you take into account in your analysis.
In my book, in the book version of this project, I begin in the 16th century, not the 20th, because that's where modern day colonialism begins. What I try to be very conscious of in every, let's say, talk I give or article I write or class I give is how material time is. If you want to understand the case law of the Strasbourg Court on migration, you have to begin in 1945, because the case law, the foundational case law of the court, Abdulaziz, and the cases, the commission cases that came before it, are about British decolonization. So you cannot understand Abdulaziz, and you have to skip pages and pages of the judgments if you don't begin in 1945. Now, so that 1945 may be the right moment to begin. For understanding the visa map I showed, I think you cannot start later than 1990, because that's when the process of harmonization began. Another perspective would be, no, you can only understand Abdulaziz if you are aware that Abdulaziz, the court saying there's a well-established rule of international law, that states can control migration and that they don't have to justify exclusion. That's the core of the judgment. Exclusion does not have to be justified. It's individuals that have to justify why they are allowed to enter the territory. So the burden of justification is on individuals in the Strasbourg system. That has been introduced by the US Supreme Court in its Chinese exclusion case law from 1889, which was explicitly racial. They said the United States can exclude from its territory people of a different race who won't assimilate. This is all, I mean, this is a literal quote. This is the language they use. Abdulaziz is the reception into European human rights law of that case law. So you might say, no, you have to go back to 1889. Then I would say, well, you can only understand the Chinese exclusion case law if you are aware that that is a complete rupture, really a complete change of international law as it was at that moment. The state of international law at that moment was still that there was a right to travel and to migrate, because that was foundational to the legitimation of colonialism. Victoria Hugo de Groot, and I recently discovered, thanks to Stefan, Blunchley in 1872 still said, it's a right to migrate. And Blunchley supports this by pointing to the 1842 Nanking Treaty, which was the Brits had won the war against China, the first opium war, and China had to open up to the British opium trade. Blunchley calls this ein großes Fortschritt für das Weltrecht. So until the Chinese exclusion case law, migration was a fundamental right. So it's a long answer, but so time really matters. And I think it's important to be aware in each move you make, how you deal with time. So that was one of the reasons why I made this talk only at the last minute. Of course, I used it. It's something I already have. I thought, well, what has been said about this before, and what can I skip? How far do I have to go back? But so it's time matters, and you don't. I mean, when you litigate a family reunion case tomorrow in a court, of course you don't go back to 1539. But I think it's important to be aware, and it may be important to point out in particular cases that the Strasbourg notion that people have to justify why they have a right to family life is not normal, and it's not the normal way of doing human rights law. Migration is the only situation in which individuals have to argue they have a right. In all other fields of law, they have a right, and the state has to argue why it can infringe on the right. So it may be time matters, history matters, and it doesn't matter always. And you have to be very conscious of what you're doing about when you decide where you begin your story.
Thank you very much, Thomas. I could hardly end on a better note, but I wanted to readdress what you just said, that you're still learning on this topic. And I think all of us, we're all learning, and we're very grateful to have been learning from you. And we're very happy to have you again anytime soon, and yeah, to learn from one another. Thank you very much.
Thank you.